G'day. Everyone here knows that I'm a huge fan of Peter Dutton, the Home Affairs Minister who no longer looks after immigration, unfortunately. Now, what you're going to be watching is about 20 minutes of video, and it's rather like what's going on with Trump in America with the Mueller investigation into collusion with Russia. In this investigation, what happened was that Dutton gave a woman who was coming into Australia a special visa pass to go and work as an au pair girl for someone that he knew. And it was a technicality. Apparently she hadn't filled in the paperwork correctly. So, no huge deal. And, might be a friend of Dutton's, but, the minister is allowed to do this sort of stuff. But the Labor Party have made a huge issue of it, and they now have a parliamentary inquiry into one visa application. Can you believe that? This is costing the Australian taxpayer tens of thousands of dollars, and it's all political. Okay, now if you watch the video that's attached, you'll see what I'm talking about. Cheers, guys. By the way, this is happening today. Today. That's the 5th of September 2016. Oh, God. Let me try again. 5th of September 2018 in Australia. And just so you know that I've got the right date, we're talking about Wednesday, the 5th of September 2018. Okay. You'll find the following video quite extraordinary. Cheers.
Statement is exclusively about section 195A.
Yep. And obviously when one hears those numbers, and a number of government ministers have referred to those numbers in recent days, they sound like large numbers, that this is not an uncommon thing for the minister to grant a ministerial intervention. You did mention in passing that of the 4,129 such interventions by Minister Dutton in his time as minister, they included visitor visas, which I assume you're talking about subclass 600 visas?
Principally, yes.
Which, in the real world, people talk about as tourist visas.
Tourist visas.
Tourist visas.
Subclass 600.
How many of these 4,129 interventions from Minister Dutton were in relation to tourist visas?
I think it's in triple figures, but I'll just get Ms Golightly to check. Across the timers.
Can you check, isn't it?
Oh, okay, yeah. So, Senator, in relation to his exercise of all powers, it's in triple figures, so I was correct in that regard, 130. Under section 195A, to be strictly analogous, apples with apples, is 25. 25
times. So we shouldn't really worry too much about 4,129 because there's a whole range of visa categories that applies to. As you say, if we're comparing apples with apples here, the particular incidents that have attracted attention were people coming into Australia on tourist visas, and there have actually been only 25 occasions since Minister Dutton has been the minister where he's intervened to allow someone to stay on a tourist visa.
Ms Golightly, just confirm.
Senator, the figures that we've quoted are the tourist visas that were granted. We don't have information on what visa they might have arrived on and got cancelled.
Okay, sure. So we should really, let's focus on these 25. Can you confirm the dates of these 25 interventions?
Not each of the 25, no.
You'd be able to take that on notice, though, and come back to us? Because they all have to be tabled in Parliament, don't they?
That's right.
Do you know when the first time Minister Dutton intervened to grant someone a tourist visa?
Ms Golightly,
No, Senator, I'd take that on notice.
It would be a matter of public record because the statements are tabled, but no,
Would I be right?
Neither of us know offhand, no.
Would I be right in saying that the very first time Minister Dutton used his ministerial intervention powers to grant someone a tourist visa was on the 17th of June 2015?
You possibly could. He was sworn in as Immigration Minister in December of 2014. You might well be right. It's a matter of public record. I would just have to check the public record because he's got a table of statement on each and every occasion when he does it.
Well, we have done a bit of research ourselves, and it appears to us that the very first time Minister Dutton intervened to use his ministerial intervention powers to grant a tourist visa was on the 17th of June 2015, which just happens to be the date of what you've referred to as the Brisbane incident. Brisbane case. The Brisbane case of an au pair arriving in Brisbane seeking ministerial intervention. So that was the first time that the minister ever exercised this power to grant a tourist visa.
That might well be the case. It's just a matter of checking the record.
Would you be able to get someone to do that while we're here today? I wouldn't have thought that'd be very difficult.
Ms Golightly, how well placed are we to do that?
We can. We've got people on standby, so we'll go and check.
So I'm just seeking a point of clarification. It's 25 since what date? We've had previous reports that it's 14.
Over his term as Minister.
Okay, thank you.
Inclusive of both being the Immigration Minister and then subsequently being the Home Affairs Minister, but also sworn as the Immigration Minister.
Okay, and not all of those have been reported yet through the normal reporting procedures?
No. My understanding is that all the tabling's up to date, is it not?
Okay.
Yes. Can I just clarify then? So and you're going to confirm this, Mr Pizzillo. The first one was the 17th of the 6th, 2015. The last one I have listed under subclass 600 is the 24th of the 5th, 2018, and that's 14 interventions. Are the remainder, you've mentioned there are 25, are they from the 24th of May to the 31st of August, are they?
Or possibly a function of the subclass that was used, whether it was subclass 600 or otherwise.
Oh, well, can we clarify what are subclass 600 interventions under 195A and what are other subclasses?
Yes, so the figures that the Secretary talked about were the figures relating to Section 195A.
Yeah.
And then subsequently of those, how many resulted in the grant of a tourist or visitor visa.
And that's subclass 600?
That's various subclasses.
Okay, so could I get a breakdown of those 25 cases by subclass?
Yes, I'd have to take that on notice.
Okay, thank you.
The reason we're keen to get that is that obviously these two cases, the Brisbane case and the Adelaide case, perhaps more that we don't yet know about, involve people coming here or being granted a subclass 600 visa, which is a type of tourist visa. And our understanding is that the number is even lower that Minister Dutton has intervened to grant, and that is that by at least the 30th of June 2018, there were only 14 subclass visas, 600 visas granted by Minister Dutton.
What's the function of just
check that?
Of checking the statements that have...
Okay, what we're looking at here is a witch hunt into Peter Dutton by the Senate. And you'll notice how they're now checking every single time he granted a special visa to somebody. And this is Australian politics, no different to America, that's for sure, and what they're doing to Trump. Here we go. Let's continue listening.
Been tabled, plus any, to Senator Kitchen's point, any statements that are yet to be tabled within the stipulated time period.
So, for all the talk we've seen over recent days about thousands of cases where Minister Dutton has compassionately, generously intervened to assist people, sometimes at the request of Labor MPs and senators, it could be that it's as few as 14 times that he's intervened to grant someone this type of visa, the first being the Brisbane case, when an au pair turns up at the airport and gets the minister to intervene to let her stay.
Well, that's just it's a matter of checking the record.
Okay, and you're going to do your best to come back to us about that today?
Yes.
Yes.
Thank you. So I'm going to stick with the 14 number because that's the best that we have at this point. Do you have any information about the nature of those interventions? Were there any more beyond these two that we know of that involved au pairs? Or people who had told immigration officials that they may end up working as an au pair in breach of their visa?
Well, I wouldn't... I'm not in a position to accept the premise of the question to this extent. The use of the term au pair has been bouncing around the media. We just deal with the facts that are presented.
Well, the facts are that
us.
these people told your officials that they were going to work as au pairs.
Again, we just deal with the facts that our officers record, and then how that's described by others is a matter for them. You asked the question, are we aware of the circumstances? Well, in each and every case, we are aware of the circumstances because we prepare the intervention submission, whether it's generated through our assessment against ministerial guidelines that the case should be referred to the Minister because it meets the criteria that the Minister has set down in the guidelines I mentioned in my statement, or the Minister calls it in and says, prepare a submission for my consideration. There's only one pathway for him.
But those submissions would always set out some of the basic facts.
Yes.
And you would be able to determine, even if you don't know right here now, whether of those 14 or whatever the number ends up being of subclass 600 visas granted, how many of them involved people who had admitted to an intention to work as au pairs, babysitters, whatever kind of phrase might be used. You'd be able to find that out, wouldn't you?
Well,
from your records.
Well, it presumes... Well, the question presumes that that admissions of that nature have been made, but let's put that to one side. Yes, we would be able to discern in each and every case what the circumstances of both the arrival of the arrived person's circumstances were, as well as what our officers had gleaned through the interview process and the discussion process, plus any other data that we're able to bring to bear, and we summarise that for the Minister's consideration.
Mr Pizzula, I think usually I'm in other estimates when you appear for this committee, but I did read some of the Hansard, and I see that I think you said, I think in the May estimates it must have been, that in fact all incidents that are, all briefs that go to the Minister are copied to you.
Yes.
So in those briefs that you must see, what's the general language? Is it au pair? Is it servant? Is it what is the language that your
I don't
officers?
think I've ever seen a reference to a servant, but
babysitter. So just so we can settle on some language. And could I ask, have you brought anyone here today? I understand there's a unit within the department that deals with ministerial interventions.
and that unit is headed by Ms Dutton.
Oh, okay, great, good. Right. And that's a ministerial intervention unit, is that correct?
Well, I'm not sure if they're called. I'm not sure if that's the proper name of the unit, but it's certainly it's a team. It's a team that deals with that function.
Okay.
But I'm happy to refer that question to
Did you
either
bring-
Ms
did you-
Golightly or Ms Dunn.
Oh, could I ask, did you bring any of those files to which we're inquiring into today? Did you bring those files with you?
No. No.
That question was directed to Ms Dunn.
But
Oh, was it? Sorry, no, we haven't.
Ms Dunn, do you have any case files at the desk with you?
No, I do not.
Thank you for clarifying that.
or electronically?
No.
Okay.
Also, our section is called the Ministerial Intervention section.
Oh, good.
At the
okay.
time, in 2015, I believe it was a different name, Complex Case Management section.
Okay, I now need to hand over to other senators, but can I ask you just briefly, Mr Pizzullo, the reason we don't allow people to come in and work on tourist visas in households is that we would create, if you like, an underclass of domestic workers, and that's not the Australian way in this nation. That is why we have strong policy parameters around this, isn't it?
Well, not only policy parameters, but the stipulated conditions are set out in the Act. To gain access to a tourist visa, you have to be here as a tourist, and one of the conditions of being here as a tourist is that you don't work.
That's right. And if we had people working while on tourist visas, living in people's households, there'd be a great many people who'd like to create a domestic worker labour force in order to do that, wouldn't there?
Well,
that's a hypothetical.
well,
I'm seeking an opinion, Chair.
Now, this is crazy shit. What that woman in the Senate has just suggested, that people who've got lots of money are creating an underclass because they're employing people to go and clean their houses and maybe look after their kids, and obviously a greenie, I would say. But think about this. There are tens of thousands of Australians who work in the cleaning industry. They clean businesses, they go and they clean houses. This is how they make the income. And this senator has just suggested that because this au pair woman, who apparently Dutton gave a special pass to come in and work, falls into the category of being an underclass because of her position. How crazy is that? Anyway, let's continue listening.
My job is to administer the legislation. The legislation clearly states that if you come here as a tourist, you engage in tourism.
Thank you.
Can I just clarify, just the legislation, but also the administrative guidelines? Do you also interpret those?
That's a separate question,
Yes,
Senator.
that's why I'm asking
it goes to, the Act has sitting underneath it subordinate legislation, as well as instruments and directions that have the force of law. And in the case of the guidelines that I mentioned, just to be clear, they are practice guidelines that are that represent guidance to our officers as to what the Minister wishes to see. They don't have the force of law, other than for the fact that as public servants we're obviously responsive to and under the direction of the Minister. So if the Minister says, we put up a submission to the Minister and the Minister says, here are the matters that I'd like to see, automatically, by way of certain filters or criteria, send them up to me, but otherwise I will reserve the right to call anything in. Those are administrative guidelines.
Okay. Senator Abetz.
Thank you, Chair. Tourist visas, by their very nature, are temporary, aren't they?
Yes.
And so that puts them into a different category. And look, the two cases of which we speak, were any of those disclosed to have a criminal record?
In the first instance, I'll defer to Ms Golightly, and if there's a need to get assistance from our Border Force colleagues, we'll go there if we have to, Ms Golightly.
Not on the information I have.
And the visa was for a period of 3 months?
That's correct, Senator.
Yep. In both cases, did either case break any condition of the visa whilst they were there for that period of 3 months, to your knowledge?
Not to my knowledge, no.
Right, thank you. Did they leave at the appropriate time under the visa?
Yes, Senator.
Right. In one case, I think they left before time, did they not?
They did.
Well, even before time, thank you. And would it be fair to say that in both cases, English was not their first language, to the best of your knowledge?
To the best of my knowledge, yes, Senator.
Thank you.
Okay, what this guy, who you can see on the screen right now, is just saying is that although Dutton gave this au pair lady a special pass, tourist pass or tourist visa, she didn't break any laws and he didn't break any laws, and this whole thing is a complete beat up by the Labour Party. Anyway, let's keep listening.
Can I just pick up on one thing there, Senator Abetz? The point about whether these people complied with the terms of their visa, which is another way of saying that they didn't go on to work as au pairs, I'm intending to ask some questions about that later, but my recollection from previous estimates hearings is that the department didn't really know whether these people had complied with their visas because no compliance work actually occurred. Is that correct?
In visas as short as this, we wouldn't normally do compliance work,
No.
Senator.
So when you say that, to your knowledge, that people complied, that's because no one ever really checked?
That we wouldn't normally check this, but also that we had no reports of such matters.
And in these cases, they weren't checked?
Senator Abetz has the call, but Senator Watt's intervention is relevant. So you don't know if these people were paid while they were here?
No,
Do you know whether Senator Watt has committed a crime in the last 48 hours? There is a presumption of innocence under Australian law, thank goodness, and this sort of besmirching does the Labor Party senators on this panel no credit whatsoever.
Okay.
If there is no evidence, there is no evidence.
Peter Dutton.
Okay, that guy's just summed it up. This is a political stunt. They're targeting Peter Dutton because he's been trying to help white South Africans get into Australia. And he has just said everything. He said that this whole thing is a complete charade run by the Labor Party. Let's hope we never have a Labor Party back in Australian politics running the country. Okay, let's continue.
And to try to prove...
You're the only two who stand up for Peter Dutton.
And to try to prove a negative is impossible, and that is why we have the presumption of innocence.
Okay, now, Senator Betts, you did try to call Senator Watt to order for failing to ask questions and making statements.
Failed.
So I'm going to
Chief.
allow you to make such statements, but please, if you'd now like to turn yourself towards questions. Thank you.
Does the department investigate cases when there is no evidence to suggest that there has been a breach?
No, we rely on leads and intelligence.
Thank you, because otherwise you would be investigating and popping into everybody's household to see whether any tourist that is visiting might be undertaking paid work, and thank goodness we do not live in a police state which engages in that sort of behaviour. Can I ask, in relation to the exercise of the ministerial discretion, that was legally engaged in by the Minister?
Yes.
And is it true, in your experience, that men and women of good faith can come to different conclusions on a similar set of circumstances?
Well, just confining myself to the section in question, that's intrinsic to the design of the section. It allows for persons outside of the decision-making process within my department to, in a sense, go to an appeal. I use that term loosely, and to have a minister exercise discretion on the same set of facts, and they take the view that they take, broader or otherwise, in the public interest, and ministers then determine what the public interest is in those cases.
And how long has this been part of the immigration law?
In its contemporary mode, ever since the creation of the Modern Act in 1989, when the Hawke government considered a series of changes that I described in my opening statement.
So it was in fact Labor Party public policy or the Labor government's public policy that determined that this would be a good inclusion in the immigration legislation, and 1989, 99, 2009, so it's been around for about 30 years now.
The Modern Act is considered to be is considered a date from 89, and we're coming up to the 30th anniversary next year.
Yeah, so this has been a part of the immigration framework now for 30 years, as established by a previous Labor government.
Well, as established by the government of the day.
Yes, which, for the record, was a Labor government. Now, is a tourist that is invited into a private home for a dinner, for example, is that tourist denied or from saying, look, thanks for dinner, can I help with the washing up?
Well, Senator, I think common sense would typically apply in those circumstances, but there are criteria that our decision makers apply in relation to the definition of work, and certainly washing up or the provision of support in that way, in kind as it were, I don't think under any reasonable definition would be considered as work. But I might just seek assistance here from Ms Dunn or Ms Golightly.
Yes, Senator, basically the definition is activities that would normally attract remuneration in Australia.
Well, I'm glad to hear that, because many a person that's been on a tourist visa has in fact stayed at our residence and has kindly assisted on occasion with washing up or preparing a meal for my wife and I was just wanting to ensure that that would not have been a breach of the law, and I think that's very important in these two cases.
You're perfectly safe, Senator. I can assure you, you haven't breached the law
to
in
establish
that case.
that. Thank you for that free legal advice.
What an experience of Australia they got.
But I think that is where the issue of common sense comes into this, that people on a tourist visa, especially with English as a second language, there may have been certain circumstances where there was not a connection in what was actually
another way
said. But that is
Senator,
but that is speculation.
Do you bring
Possibly.
an interpretive service? You would have an interpreter if someone required an interpreter.
We have a
Yes.
general service available.
Yeah, so they're not disadvantaged in any way.
Well, they might.
Well, we have interpretive services
Yeah.
available to people in detention so that they can access
And in the Adelaide
information
case,
in their
of
own
course,
language.
Ms Dewell had been here on and off since 2012, so her English was probably not too bad.
I'm not going to.
How could the witness possibly?
I'm not going to speculate on their
Yeah,
identity.
exactly.
All right, well,
Exactly.
Mr Pizzillo is the
Can I-
Secretary of the
can I-
Department for
The Senator
the
Abetz got the call or not, Chair?
Senator Abetz
Thank you.
has the
Can
call.
I-
Thank you.
Please continue with your question.
The general framework of the immigration legislation is relatively prescriptive.
Yes.
And that is why it was determined, one assumes, some 30 years ago, that there should be a safety valve or a ministerial discretion to allow for cases to be considered by the Minister. Has the department itself, from time to time, had to come to a decision on the legalities denying a visa and then suggesting that it might be appropriate for ministerial intervention? And the reason I ask that is, whilst you're thinking of that, if I recall correctly reading a number of AAT determinations, the members of the Administrative Appeals Tribunal put into their decision, under the law I cannot grant a particular visa, but then, I don't want to demean the members of the AAT, but gratuitously suggest that this may be an appropriate case for ministerial intervention. That is not unheard of in the AAT. Can you confirm that?
The best way to answer the question, I wouldn't presume to speak about AAT procedures or guidelines, but in terms of the guidelines that I mentioned in my opening statement, it addresses directly the point that is contained as a premise of your question. Are there guidelines that are agreed as between the Minister and the Department, endorsed by the Minister and suggested by the Department, whereby we say, look, there are a number of matters that are likely to come before us where the case is either going to be one where you might well form a different view through the application of what you consider to be the public interest or alternatively a common sense test, and if it meets certain thresholds and triggers, we will refer these matters to you, and then you can decide whether or not to exercise your intervention power. Intrinsic to that, because otherwise you wouldn't, intrinsic to that is the idea that an officer in the department is likely in those circumstances to come to a different view because they're reading the Act very strictly, and it gives the Minister an opportunity. The safety valve was a remark that you used, and it certainly was intended in the 89 legislation. In fact, if you go back to the Parliament's intention in terms of the explanatory memorandum and the debate around the passage of that legislation, because the government decided at that time, and if I recall rightly, it passed with support of both sides of Parliament, if I recall rightly, that over the years since 1958, when the Act had come in the post-war period, practice, guidance, procedures had been built into decision-making, and one officer's interpretation of who a visitor is or who a tourist is or what the definition of work is or what a working holiday is would vary from district to district, team by team, etc. The government of the day, led by, in that case, if I'm right in recalling, Immigration Minister Ray, said what we really need to do is codify what these things mean, codify the stipulations quite rigorously and prescriptively. So Miss Golightly has a whole division, not Miss Dunn's division.
Okay, I'm going to leave it at that because this is going on for hours. But you can see how the Labor Party are trying to vilify Peter Dutton, the Home Affairs Minister, who no longer looks after immigration anyway. This is Australian politics, and that's why I say it's a huge concern if the Labor Party get into power next year. Okay, I'm going to leave it at that. I'm just bored of this crap. Okay.